Good morning, everybody. I trust your Wednesday is going really, really well. And thank you for joining us today. We really do appreciate you taking a time out. Hope you got a good cup of coffee to spend the next hour with us as we talk about something really important that's become increasingly important in the pandemic, that being the medical surveillance requirements and what is really needed for the food industry. I have with me today two very special guests. I have Ms. Jabulile Mhlophe, and she's from the Department of Employment and Labour, and I have Janusz Luterek from Hahn and Hahn. Both will be giving us two very informative presentations from two different sides of the table, and I trust that you will benefit from it.
Thank you so much, Linda. Good morning to everyone. My name is Jabulile Mhlophe. I'm the specialist in occupational health and hygiene in the Department of Employment and Labor. So one of my duties is to deal with the hazardous biological agents regulations that I'm hoping, as you are in the food sector, you are familiar with that regulation. So my presentation today is going to be on medical surveillance in the food industry. I'm going to touch briefly on the Occupational Health and Safety Act and also on the regulation for hazardous biological agents. All right, the content of the presentation is going to be introduction, hazardous biological agents regulations, and the requirements under the regulations, which will be the scope of application, indicative list of incidents, hazardous biological agents, risks groups of hazardous biological agents, risk assessment, medical surveillance, and then conclusion. Next. Okay, what is medical surveillance? Medical surveillance is a planned program or periodic examination of employees exposed or potentially exposed to occupational hazards. Meaning it's not just a haphazard process, but that program needs to be planned. And this medical surveillance, it may include clinical examination, biological monitoring, or medical tests of employees. It needs to be conducted by an occupational health practitioner or in some cases by an occupational medicine practitioner. Why specifically occupational health practitioners is because we are talking about illnesses that are being got by the employees at work. Therefore, these practitioners, they've undergone another diploma on occupational health, so they have a better understanding of occupationally acquired diseases. So not just a medical practitioner should be in control of medical surveillance for occupational health purposes. It is risk-based, meaning that not all employees might be included in the program. Therefore, it's very important that whoever is conducting a risk assessment must be competent enough to identify those employees that must undergo medical surveillance. As we are saying, it is risk-based. It doesn't mean that all of the employees should undergo medical surveillance. The main purpose of a medical surveillance is an early detection of ill health to employees and the effectiveness of exposure prevention strategies. Remember, if there are employees who might be exposed to a certain hazardous agent, control measures need to be put in place. So medical surveillance, when the employees undergo this surveillance, it will detect whether the control measures that are in place are effective or not. Also, to identify the early detection of ill health. It is that important that the employer provides a health and safe working environment for his employees, and that a risk assessment is conducted by a competent person who will be able to identify the potential hazards in the workplace. Next. Section 8, subsection 1 of the OHS Act number 85 of 1993 states that every employer shall provide and maintain, as far as is reasonably practicable, a working environment that is safe and without risk to the health of his employees. Section 8, subsection 2 further states that an employer shall take steps as may be reasonably practicable to eliminate or mitigate any hazard or potential hazard to the safety or health of employees before resorting to PPE. Therefore, the employers have to ensure that wherever the employees are at work, they have mitigated all the hazards that might be in the work environment. Section 8.3 saying an employer must make arrangements for ensuring, as far as is reasonably practicable, the safety and absence of risks to health in connection with the production, processing, use, handling, storage, or transport of articles or substances. Next. Section 41B of the OHSS states that the minister may make regulations which, in the opinion of the minister, are necessary in the interest of health and safety of persons at work, or health and safety of persons in connection with the use of plant or machinery, or the protection of persons other than persons at work against risks to health and safety arising from or connected with the activities of persons at work, including regulations as to the production, processing, use, handling, storage, or transport of and the exposure of employees and other persons to hazardous articles, substances, or organisms, or potentially hazardous articles, substances, or organisms, including specific limits, threshold, or indices or of such exposure. Meaning that with all that I have just mentioned, the minister has got the authority to make regulations under the activities that I've just mentioned. Therefore, one of the regulations that addresses the issue of organisms is the regulations for hazardous biological agents. Next slide. I hope you are all familiar with these regulations because they are fully applicable in the food sector. HBA regulations apply to every employer and self-employed persons at the workplace where HBA is deliberately produced, processed, used, handled, stored, or transported. As number A usually is applicable to the laboratories or researchers or the scientists because they handle these hazardous biological agents deliberately due to the nature of the work that they are doing. Or apply in workplaces where an incident for which an indicative list is given in Annexure A to these regulations occurs that does not involve a deliberate intention to work with an HBA, but may result in persons being exposed to HBA in the performance of his or her work. Therefore, we are going to now go through the indicative list that will show that at times we not handle these HBAs deliberately, but due to the nature of the work that we are doing, the employees become exposed to HBAs. Next slide. Okay. Incidents or exposure during work occurs at the following workplaces: in a food production plant, where there is contact with animals or products of animal production; in healthcare, including isolation and post-mortem units; in clinical, veterinary, and diagnostic laboratories; in sewage purification installations; and in a general workplace. Therefore, with these workplaces, HBAs are not deliberately handled as in a laboratory or when they conduct research, but employees might be exposed to them. What are these hazardous biological agents? They are living organisms or products of living organisms. They include viruses, bacteria, and fungi and their metabolites, as well as parasitic worms and plants. HBAs are infectious and toxic, but they can also cause allergic reactions, such as hypersensitivity pneumonitis, allergic rhinitis, some types of asthma, and organic dust syndrome. The workplace provides an ideal place for the proliferation of microorganisms and spread of the disease, as people spend approximately 90% of their time indoors. Next. Also, these HBAs, they are categorized into 4 groups. Like we've got group 1, where they are unlikely to cause a human disease. For an example, the bacteria that we use in the fermentation process, those ones fall under group 1. Group 2, they cause human disease, may be hazard to employees, unlikely to spread to community, but there is effective prophylaxis or treatment available. For an example, a hepatitis B virus. Group 3 can cause severe human disease, may be a serious hazard to employees, may spread to community, but there is prophylaxis or treatment that is available. For an example, if we take a Mycobacterium tuberculosis. Group 4, they cause severe human disease, serious hazard to employees, likely to spread to community. Usually there's no prophylaxis or treatment available. For an example, an Ebola virus. Therefore, when a person conducts a risk assessment, they need to identify the different groups whereby the agents that are found in the workplace, under which group are they falling into. When it comes to risk assessment, an employer or a self-employed person shall, after consultation with the relevant health and safety reps or relevant health and safety committee, cause a risk assessment to be made, and thereafter at intervals not exceeding 2 years, to determine if any person might have been exposed to HBAs. An employer shall inform the relevant health and safety rep or health and safety committee in writing of the arrangement made for the assessment contemplated in subregulation 1, give them reasonable time to comment therein, and to ensure that the results of the assessment are made available to the relevant health and safety rep or health and safety committee so that they can comment on them. When making the assessment, the employer or self-employed person shall keep a record of the assessment and take into account the following matters: the nature of the HBA, whether it's a virus, it's a bacteria, it's a fungi, or it's a mold or whatever, which employee may be exposed, and the suspected route of exposure. As we know that there are different routes of exposures, there's inhalation, ingestion, and all the others. And also where the HBA might be present and in what physical form it is likely to be, the nature of the work and work processes, and any reasonable deterioration in or failure of any control measures. And also what effects the HBA can have on an employee during the period of exposure. An employer or self-employed person shall conduct the risk assessment on the basis of all available information, including classification of the HBA into the relevant risk groups according to its level of risk of infection. Recommendations from the manufacturer, supplier, or competent person regarding control measures necessary in order to protect the health of persons against such agents as a result of their work. Meaning that depending on the agent that employees are exposed to, there are specific control measures that need to be put in place. Information on diseases that may be contracted as a result of the activities at the workplace, potential allergenic or toxic effects that may result from the activities at the workplace, knowledge of diseases from which employees might be suffering and which may be aggravated by conditions at the workplace. Therefore, it is so important that whoever conducts a risk assessment must be a competent person who is familiar with the workplace, who is familiar with the agents found in a place, and what ill health they can cause to the employees. An employer shall review the assessment required by Sub-Regulation 1 forthwith if there is a reason to suspect that the previous assessment is no longer valid. For example, with the coronavirus, there were other additional measures that were supposed to be put in place by employers. For an example, the issue of social distance. So I'm hoping that as a food sector, you did revise your risk assessment to ensure that you include the new requirements in terms of as required by the coronavirus, because the coronavirus is also a hazardous biological agent. Also, has been a change in a process involving HBA or in the methods, equipment, or procedures in the use, handling, control, or processing of HBA, and the provisions of Sub-Regulation 2, 3, and 4 shall apply. So if there was a change in a process within the period of 2 years, you need to revisit your risk assessment. Now we come under medical surveillance. Under the OHS Act, medical surveillance is defined as a planned program or periodic examination, which may include clinical examination, biological monitoring, or medical tests of employees by an occupational health practitioner or in prescribed cases by an occupational medicine practitioner. The hazardous biological agents states that an employer shall ensure that an employee is under medical surveillance if the results of the risk assessment indicate that an employee might have been exposed to an HBA, or the exposure of the employee to any HBA hazardous to his or her health is such that an identifiable disease or adverse effect to his or her health may be related to the exposure. There is a reasonable likelihood that the disease or effect may occur under the particular condition of his or her work. There are techniques such as preclinical biomarkers where appropriate for detecting sensitization to allergens or an inflammatory response associated with exposure to diagnose indications of the disease or the effect as far as is reasonably practicable. I might say that most of the time in the workplace, issues of allergic or inflammatory response to an exposure, they are most of the time missed by the employers. An occupational health practitioner recommends that the relevant employee should be under medical surveillance, in which case the employer may call upon an occupational medicine practitioner to ratify the appropriateness of such a recommendation. In order to comply with the provisions of Sub-Regulation 1, the employer shall, after extensive counseling and education, offer the employee an opportunity to have an initial health evaluation, which should be carried out by an occupational health practitioner immediately before or within 14 days after a person commences employment, where any exposure exists or might exist. So a pre-medical examination, it is a requirement in terms of the hazardous biological agents when a person is going to be exposed to an HBA. It comprises of an evaluation of the employee's medical and occupational history, a physical examination, any biological tests, and any other appropriate medical tests, or any other essential examination that is the opinion of the occupational health practitioner is desirable in order to enable the practitioner to do a proper evaluation. Periodic medical examination and tests in cases where an HBA is known to be capable of causing persistent or latent infections which, in the light of the present knowledge, are undiagnosable until signs or symptoms develop, can have a particularly long incubation period, can result in an illness which is recurrent in spite of treatment, and are known to have serious long-term effects. So why do we do these periodic medical examinations? To see, to track the progress of the employee of a certain ill health. If it's becoming worse, then that employee maybe might be given another duty to perform and be removed from the workplace where she or he is performing the work. Therefore, it's important that periodic medical examinations are also done. All tests and examination as contemplated in paragraphs A and B shall be conducted according to a written medical protocol. The employer shall, in accordance with Regulation 8 of the General Administrative Regulations, investigate and record all incidents that result or might result in infections or death of an employee. All occupational health practitioners shall submit to the Health and Safety Committee for approval a written protocol for procedures to be followed when dealing with abnormal results. In conclusion, the prime purpose of medical surveillance is prevention. That's why we say it's an early detection of ill health so that it can be prevented. The medical surveillance program should have a clearly defined purpose, objective, and a defined target population and testing facilities. It may include questionnaires, physical examinations, and medical testing. The availability of effective interventions is an important consideration in establishing a medical surveillance program. It is important that a clear plan is established for interpreting the results and presenting the findings to employees and management of the affected areas. Thank you.
Thanks, Jabu. That is a lot to consider. Thank you for working with me in terms of the delay on the slides. I do apologize, everybody. There was just a slight delay. Jabu, I want to just ask you a few questions, if you don't mind, in relation to your presentation. I like the fact that you said the risk assessment is so critical and PPE is our last resort. I think in many cases we want to throw PPE at a problem as employers, but actually we should be trying to remove the root cause of the hazard as opposed to just expecting our staff to wear PPE. I think we've all experienced the challenges during lockdown, how difficult it is to work with a mask on. And if we just throw a dust mask at a dust problem, we're actually not solving the problem. We're making it very difficult for employees to work under those conditions.
Yes.
I think one of the takeaways to everybody listening is obviously the importance of laboratory staff. I think many food companies have an in-house laboratory where they possibly are dealing with hazardous biological agents, and the importance of ensuring that their risk assessment takes those staff into account. So thank you for that. The other point you mentioned regarding allergens and inflammatory responses and the fact that this is often missed. I think in areas where we're dealing with dust products, powdered products, definitely overlooked, not necessarily taken into account that staff may develop allergens, an allergic reaction. I wanted to just ask you about the pre-employment medicals. In the context of your presentation, you've mentioned hazardous biological agents, but those are obviously not the only agents that we have to consider within the food industry. We would also need to consider hazards such as noise, working at heights, stress factors related to the job. So I'm assuming that your pre-medical screening would therefore take into account hearing, plus possibly existing conditions such as hypertension, possibly diabetes, those aspects which could become a problem to the employee depending on the work conditions.
It's true. It's just that I was just focusing on the HBA regulations, but if we check all of our hygiene regulations, pre-medical is a requirement, whether a person is going to be exposed to chemicals, to noise, because you need to get a history of this person. For an example, if this person is going to be exposed to a noisy environment, you need to check his noise rate, his noise levels, his hearing noise levels. Where is he coming from? Was he working where he was exposed to noise? And what is his or her threshold now before you take him to a noise environment?
Absolutely. Now, based on what you have explained to us today, I think the hazardous biological agent regulations are not new. COVID-19 is new, but those regulations are new. So we have to overlay the additional requirements for physical distancing and those risk mitigation measures, overlay those on the regulations that we're already supposed to be administering as employers. Am I correct?
You are very much correct. Because when you look at the annexures, we've got a family of the coronavirus under the list. But the strain, the difference is the strain of the family of the coronavirus. But we do have a classification of the family of the coronavirus under our regulations.
Great, super. Okay, so I think the point I wanted to make with Jabu's presentation is that the controls that she's mentioned, the regulations that she's mentioned are all within the context of protecting our employees and protecting our employees from the work environment and making sure that they are safe. I think the COVID-19 pandemic has focused our attention as an employer on how important this aspect is. And if we were previously not taking our employees' health and safety seriously, we definitely should be doing that now. And Jabu, am I correct in saying that on the 6th of October, additional medical surveillance requirement regulations were introduced where an employer is now responsible for submitting a report of ongoing medical surveillance in relation to the symptoms of the pandemic, through to the National Institute of Occupational Health?
Yes, there is a requirement that when there is a positive case that has been identified at the workplace, then the NICD needs to be informed.
Absolutely. And I think also in addition to that, on the 6th of October, these regulations also now require the ongoing medical records to be submitted as a report to the National Institute for Occupational Health. And this is now, it used to be for employers with 500 employees. Now it has been reduced to 50 employees. Yes. And so again, for those of us that are involved with this in the food industry, please to take note of this very important change that was made just recently. Jabu, thank you very much. Please stay on the line because I'm sure there will be some other questions in relation to this. Thank you so much for your presentation. Thank you, Janusz. First of all, just a bit of an introduction. Who is Janusz Luterek?
Hi, all right. Good morning, everybody. Those of you who don't know me, so I'm an engineer who worked in the food industry. I then studied law, became an attorney, also a patent attorney, as you'll see. But for the last 13, 14 years now, I've been practicing in the field of food law, and I have many clients in the food industry. I'm a member of SAFOST, and yeah, I have extensive experience in this field. My presentation today will focus on the food law aspects of this topic. The Occupational Health and Safety Act and Employment and Labour was covered completely and in an exemplary fashion. I not only have nothing to add, but that's not my field, so I really don't know that much, and I found it to be a very interesting presentation. going to address this from the Foodstuffs, Cosmetics and Disinfectants Act, and particularly the so-called hygiene regulations, or R638. So just to offset where we are with this, so just to understand that the previous speaker spoke from the perspective of the person, their health, the employee. Obviously, the employee's health can impact on the food and therefore on the health of the public, but essentially the Department of Employment and Labour is looking at the health of the employee as a person. The Foodstuffs, Cosmetics and Disinfectants Act is looking at the safety of food and thereby the safety of the public. So let's quickly look at this. So under the disaster management regulations under the Department of Labour, there are aspects dealing with the public transport of workers, physical distancing, masks in public spaces, there's the hand hygiene issues. So we know about all these things. We all know we have to clean our hands with at least 70% alcohol, etc. When looking at the risk aspects, specifically, for example, now in terms of coronavirus, the Department of Labour actually put up a very interesting chart, which is very useful for assessing the hazard and risks associated, for example, with coronavirus. But this type of hazard and risk identification could be applicable across the board to all risks, I suppose, even the ones that the previous speaker spoke about. And it's quite important, as the speaker was saying, is that PPE is in fact the last one. If you look at the bottom, you should first try and change people's behavior, look at engineering and environmental circumstances, etc. And only when all of those things have been done will you then start using PPE to remove the final level of risk. But this is a very nice chart to look at. And of course, it's possibly not applicable, because if you look at a coronavirus situation, we can't eliminate it. There's nothing you can substitute in your factory or in your business in order not to get coronavirus. So whereas in a different working environment, you may be able to already get rid of the problem at level 1 or level 2 by elimination or substitution, this can't be with coronavirus. One of the reasons I want to talk about coronavirus is that up to now, people have been saying, well, coronavirus is not a food transmissible disease. But as was recently disclosed in research papers, in China, they have found coronavirus on frozen foodstuffs. So therefore, if you bought that frozen foodstuff, you could actually get coronavirus from the packaging and potentially from the frozen fish, which in that case as well. So it's quite useful to understand the risk analysis of a coronavirus situation. But let's talk about the hygiene regulations, which is R638, which is really where I deal with. So we need to understand it's primarily concerned with public health issues of food, and it deals with the production, distribution, and retailing of foodstuffs. The regulations relate to food safety and hygiene at such premises. So it will be the hygiene of the people who are handling the food, but insofar as they affect the food safety of the food. And then the obligations of the person in charge at such premises and the food handlers and, for example, delivery drivers to ensure hygiene and food safety of foods. And we need to understand here that, and those of you who have heard my presentations before will know I hammer on this, that in a food facility, the so-called person in charge who is named on the COA is ultimately responsible for the hygiene and the food safety of what happens within those premises. So under the occupational health and safety issues, as we've said, staff safety issues are primarily regulated under the OHSA Act, and this law deals with safe working environment and obligations of the employer and employee. And maybe I just want to highlight that people often say, oh, well, it's just the employer's responsibility, but of course it's not. The employee themselves also have an obligation to provide and maintain a safe working environment for all employees. So as an employee, once the employer has provided you with a safe working environment, you must ensure that you don't create a bad environment for your fellow employees. So in terms of R638 under the Foodstuffs, Cosmetics and Disinfectants Act, every premises must have the certificate of acceptability of premises, and there it says that you may not handle food or permit food to be handled on food premises unless you have a valid certificate of acceptability. And if such has not been issued or is not enforced, then you can't handle any food on the premises. And this also applies to outsourced vehicles used for the transport of perishable food on behalf of a person in charge of a food premises. And it's also illegal to operate a food premises in contravention of any restriction, condition, or stipulation contained in a certificate of acceptability. So when you want to open a food premises, in EHP will come, they inspect the premises, they inspect the hygiene aspects thereof, they inspect your registers, and they will again do this when they come and do regular inspections at your premises. Initially, they will recommend the issuing of such a certificate to you, but on an ongoing basis, they will check to make sure that you're still complying with it. Otherwise, they could potentially suspend your certificate. So the person in charge of the food premises has certain responsibilities as regards the hygiene and food safety, and therefore what the food handlers, the people who handle the food, their medical conditions and so on. So it says, the person in charge of food premises must ensure that the provisions of the regulations are complied with, and a condition, act, or omission that may contaminate food does not arise or is not performed or permitted on the food premises. So already you can read into this that if your employees have some other medical condition that they are bringing into the premises and you have no means of checking and you're unaware of this, you will in fact be permitting them to contaminate the food, and therefore you will be contravening these regulations. Also, persons under his or her control who handle foods must at all times meet the standards and requirements and execute the duties prescribed in regulations 9 and 11, and I'll get to regulation 11 shortly. And then at 10 sub-regulation 15, it says that this person in charge has an obligation on the reporting of diseases and conditions contemplated in regulation 11.2b, which I'll get to next, and that these are properly recorded and kept for perusal by an inspector. Now, potentially where this gets complicated is that the Department of Labour has its surveillance and screening and its registers. This is a different inspector who's coming to look at it from a different perspective, but will also want to see your register. But this register will only relate to the issues which fall under the Foodstuffs, Cosmetics and Disinfectants Act, and may in fact not overlap necessarily with those under the Department of Labour and Employment. So in terms of the person who handles food, a person may not handle or be allowed to handle food without wearing suitable protective clothing as specified. So although we say that PPE is the last step and you have to do everything else first, in terms of food handling premises, there are certain circumstances when PPE is prescribed. You cannot choose not to have PPE because you have done other things. And in terms of the COVID-19 pandemic, it is possible to transmit the virus in food. It now appears, particularly it appears through packaging and through frozen foodstuffs. I'm not a microbiologist. I don't know why it will be particularly on frozen foodstuffs. It may be temperature dependent, that the virus is sensitive to high temperature, but not low temperature. And then there's the issue of wearing protective clothing, especially gloves and masks. Now, gloves in the food industry specifically are usually not prescribed. So whereas other PPE is usually prescribed under R68, the wearing of gloves is typically optional. But now when we come to the circumstances of something like the coronavirus, it may in fact be that the use of gloves is required rather than not required. Again, there can be a debate around this point. It's not specifically prescribed, but you do have the obligation not to allow contamination and spread of any illness someone can have. And as I said, as we now know, the virus can survive for at least several days on packaging, possibly crates, vehicles, etc. Regulation 11 is the more important one. So Regulation 11 says that food, a facility or a container may not be handled by a person, and here comes the 11B1, which was referred to under the obligations of the person in charge. So food may not be handled by a person who has reported or he is suspected of suffering from or being a carrier of a disease in its contagious stage, likely to be transmitted through food. So unlike the Department of Labour and Employment Act and regulations, this one is only concerned with diseases which are likely to be transmitted through food. So you could have a disease which cannot be transmitted through food, and then it would not be regulated under R638. So, and it's only when it's in its contagious stage, and it must include certain what am I looking for? The diagnoses or whatever: diarrhea, fever, sore throat with fever, etc. Now, if you look at those actually overlap to some extent with coronavirus symptoms as well. So a person who reports for work, and now you're measuring their temperature because of the emergency disaster management regulations and the Occupational Health and Safety Act regulations. You now measure their temperature and you say, oh, I suspect them of having COVID. Not only do you have to take the steps you would under those regulations, but suddenly this person would fall within this regulation as well. And that person referred in subparagraph 1 may only resume handling of food, work in a facility or handle a container if that person submits a certificate by a medical practitioner stating that the person is fit to handle food. Very important, not stating that they are now well or that they no longer have some other illness. The medical practitioner must issue certificates that they are fit to handle food. The focus here being, will they contaminate the food and will they spread the disease through the food? Just a different perspective, just keep your eye on that. So therefore, any person exhibiting any of the symptoms of COVID-19, such as diarrhea, fever, sore throat with fever, should not be allowed to handle food. Not only because they may have COVID-19, but perhaps they don't have COVID-19 and they have something else which has diarrhea, fever, sore throat with fever, which can be spread through food. But very importantly, and unfortunately, I've come to the realization this doesn't happen a lot in the food industry. That employee should only be allowed to return to work when a doctor certifies them fit to handle food. It's not that they've been away for 10 days, they've got no more symptoms, now they can come back. This regulation clearly says that a doctor must certify them that they can handle food, because they may not have any more symptoms, but they may still have a virus or a bacteria which can be transmitted through food, very importantly. So let's just talk about another aspect which is close to my heart, and that is food deliveries. And I thought, let me throw it in here because I really think it's important. People often don't think of food deliveries. You know, during lockdown, we all learned to order everything, and everything gets delivered to you, and it's contactless deliveries and so on. So where do they fit in under these hygiene regulations? So a food handler is someone on the premises who directly handles or comes into contact with packaged or unpackaged food, food equipment and utensils, or food contact surfaces. But the food premises can be a building structure, stall, or other similar structure, and includes a caravan, vehicle, stand, or place used for in connection with the handling of food. So therefore, someone working on the side of the road in one of those caravans serving boerewors rolls is actually a food handler. But someone in a vehicle in which food is being transported is also a food handler. So therefore, packers and delivery vehicle drivers and delivery staff are all food handlers. And everything I've said up to now applies to them. Where is the problem? Who is responsible to ensure this in respect of drivers, etc., and food packers and so on, when many of them are either temporary staff or are self-employed? They have an app tells them to pick up a pizza and take it from here to there. Who is checking that they are compliant with R638? This is a very important question because they could in fact be in contravention of this, but there's no one to check it. Because never mind having 500 employees or 50 employees, they are a sole employee, they are self-employed. So in terms of subregulation 14.6 of R68, a vehicle delivering pre-packaged food owned by the same owner as food premises may be included in the COA of the food premises, and therefore the person in charge is responsible. So if you're a big food retailer or a quick serve restaurant and you have your own delivery drivers, in fact you're responsible for them. You need to make sure that they comply fully with R638, and by the way, that the vehicles comply with R638 in terms of hygiene, that they are regularly washed, etc., etc. But if you are using a third-party delivery service, outsourcing, you need to just make sure that they have a COA in the name of the person in charge of the delivery vehicles, which is not you because you're outsourcing it. You've got no control over those drivers and the vehicles. But the problem comes in, of course, when it's an independent contractor. If it's a logistics company, I think it's quite easy. You can insist, look, you need to make sure all your drivers comply, otherwise we cancel your contract. But in many instances, these delivery drivers are self-employed, and therefore there's none of this checking happening, and I fear to say there's no compliance. So the person in charge of the drivers would be responsible for compliance with the above obligations as if they were a food handler, because they are a driver or a delivery person. The Occupational Health and Safety Act, again, just to refer you back to that, just to remind you, regulates the safety of the employee, i.e. the food handler, such as the driver or delivery person. So the OHSA Act doesn't look at whether that driver will infect or transmit disease to the end consumer who's getting the pizza. The OHSA Act is looking as to whether the driver's health is being looked after. Of course, if they are healthy and they don't have any disease, they're not going to transmit the disease. But that's not the objective of the OHSA Act. So the employer must be reasonably practicable, provide and maintain a safe, healthy work environment without risk to employees. The employees, in this case, for example, the drivers of delivery people, must be properly educated about the risks they're exposed to and what precautionary measures are to be taken. You know, these poor drivers that deliver all these foodstuffs, they go from door to door, they're exposed to probably tens of people every day. And the training about how to ensure that they don't get infected with coronavirus, or for that matter of fact, TB or some other disease, from the person at the doors to whom they hand the pizza, is really important. But of course, the employee themselves has an obligation to maintain the safe working environment. So once you've educated them, you've given them the PPE, you've done everything that needs to be done, you've given them the hand sanitizer, that employee then has the obligation to make sure that they in fact wear the PPE when they need to, use the hand sanitizer when they need to, and carry out all the responsibilities. So finally, the conclusion on this topic. So the person in charge of food premises, whether that be the producer or retailer, has an obligation to ensure that production and deliveries from their premises are carried out in a safe manner and in accordance with R638. Where their own vehicles are used for delivery, they are in charge and have the obligation. Where deliveries are outsourced, the outsourced vehicle must either have its own COA or be on the COA of the owner operator of the vehicles. Of course, there's got to be a stick, and the big stick at the end is that in terms of R638, if you're not compliant, if you're not keeping a register of people's illnesses, you're not making sure that people with a suppurating, I think, what was the word in the regulation, a suppurating abscess or wound aren't handling food, etc., you can in fact be prosecuted as the person in charge, and therefore you could get a fine or imprisonment in terms of the Foodstuffs, Cosmetic Disinfectants Act. There may be further prosecution in terms of the Occupational Health and Safety Act, because quite frankly, if you're contravening this, you're probably contravening the Occupational Health and Safety Act as well. And then just finally, there are other hygiene considerations in light of COVID-19. As I said, there are the consolidated directions on occupational health and safety measures in certain workplaces of 1 October 2020. There's the World Health Organization interim guidance documents on COVID-19 and food safety. of 7 April 2020. That one may in fact already be overtaken by these cases they've had in China of the frozen foodstuffs which are found to be carrying COVID. And then there are consolidated directions on occupational health and safety measures in certain workplaces. And as I say, this applies to all workplaces, including food premises. You need to protect employees, which ultimately protects the consumer, but that's not the purpose of it. And then there are relative directives in terms of hygiene, such as social distancing measures, sanitizers and disinfectants, and washing of hands. And there's a 70% alcohol requirement in hand sanitizers. You may have noticed there are places that don't use 70% alcohol. They're using a quaternary ammonium compound with peroxide mix, which is in fact in contravention of the regulation. The regulation specifically says 70% alcohol. There's the requirement to have cloth masks and how many per person, the fact that you need ventilation on your premises, what PPE you need, and then of course sectoral protocols and guidelines, and then there are some specific to the food sector. So the whole issue of the health of the employee is quite complicated. It's regulated by several laws and regulations, and it may be that in a company, different people are responsible for different aspects. The medical surveillance record that Jabu spoke about may in fact be dealt with by a completely different person, especially in a large company, than that related to R638 and a particular food handling premises. And these are just the guidelines from the WHO, but as we know, they're not binding. It's purely a good guidance of how one should be doing things, use of gloves, physical distancing, all of these things we know about. So yes, I hope I didn't confuse you by explaining that, in fact, there are different laws that seem to overlap in the way that they regulate things, but hopefully you now understand that they in fact don't regulate the same thing. Thank you.
Absolutely. Thank you very much, Janusz. I think that is the important point that we did want to make in relation to this particular requirement, and that is that you have two different sets of regulations, but they serve a different purpose. The one being to protect the product from a sick employee, the other being to protect the employee from a potentially sick environment or an environment where they could get sick as a result of a number of factors, but as Jabu said, hazardous biological agents. Janusz, I just want to ask you a couple of questions, please, if you don't mind. The first one being in relation to you mentioned the aspect that there is some evidence that suggests that the virus may be transmitted via other surfaces that are associated with the food industry. I think it's important just to bear in mind that I know the ICMSF have since released a position paper in that regard, and so I think it is important to look at the most available information in that respect, and I think their standpoint is still that it is highly unlikely, but I think in relation to the current practices, people have been conservative just in case, which I think as consumers we appreciate. If I take other, you mentioned the use of gloves and the need to protect the product. It's not a mandatory requirement, but I think if we consider things like salmonella, hepatitis, those are most definitely illnesses that can be transmitted from a food handler to the product and then to a consumer. And that's obviously the focus of the hygiene regulations. Salmonella, you can shed salmonella for 55 days after, symptoms. So I think the point you made regarding the fit to work is absolutely critical before we allow that person to come into, back into the workplace. And I think that, is this an area where you see the food industry lacking?
Yes, I mean, I've had clients who I consider to be compliant. Some of the most compliant clients I have, who spend huge amounts of money on legal compliance, goes above and beyond in many respects, but whose practice is if somebody's been ill, if they've been off for a week, then they're feeling better, they can just come back. Now, that's probably fine 99.9% of the time because it was flu or it was food poisoning or something like that. But you're correct, there will be that case where they will allow somebody to come back to work who could potentially start shedding salmonella or hepatitis A, or who knows what can be going into the food. So, and their point is that we can't expect the staff to go see a doctor twice, because who's going to pay for it? And that's, of course, a very interesting point, because if you have a food handler in the kitchen and he's now preparing salad, something that's uncooked, so there's no kill step, and he now gets sick and you send him home and he has to now go see a doctor and he gets some medicine and he's already spent money, and now you tell him you can't come back until you see a doctor again and bring me a certificate. In many cases, the staff say, well, we don't have that sort of money. So it is a wider social problem, I think.
Absolutely.
That,
yeah, and I think there's also, you know, other implications regarding people having to take time off work, and, you know, if they are off work for the amount of time that they have to, does that become a leave issue? And what does the employer do in that regard? I think there are a number of situations that we as employers have actually created for ourselves, where employees are not willing to actually even make us aware that they're ill, because it has a negative impact on them in many cases, because we haven't thought through proper policy regarding what will we do if someone is ill and poses a risk to the product and poses a risk to the consumer. So, you know, I think that you've sort of emphasized the fact that we need clear policies. Those policies also need to take a number of factors into account, not just the letter of the law. It's the spirit of the law and also the spirit of good work relations, I think, in respect of employees.
And I think part of the problem also comes in is that there's a very large range of business sizes. Some are multinationals and they have the wherewithal. They may have in-house medical surveillance staff. They may have a medical center. But it goes right down to the so-called mom and pop store.
Absolutely.
And they are really struggling to survive. And they say, well, every time an employee gets sick leave, first of all, they're off, we have to pay them sick leave. Now we've got to pay for a doctor to tell us they can come back. So one can almost see the other side of it, you know. So somebody has to pay for this doctor to tell the employee they can come back to work.
Yes.
It is a difficult problem. And I suppose if our public health worked better, and the employee, and there were, or maybe Department of Labor had a medical arm where employees could go to get cleared, they can go back to work, so that, because it comes down to money, you know, people don't want to pay, so they'll take a shortcut.
Yeah, absolutely. And that can result in outbreaks of foodborne illness. I mean, if you just take what's happened in the States, just in, you know, the last year, the number of hepatitis outbreaks linked to food handlers has just gone through the roof. And, you know, I think it's something that we're not even really paying attention to within South Africa.
Well, I've got to say, I mean, hepatitis isn't one of those that would fall under a regulation 11B1 or the one which says what 11.2B1.
Yeah,
first of all, because the employee has to report that they're sick.
Absolutely, but I think in relation to jaundice is often one of the symptoms, and so we pick it up. Yeah, we pick it up there in relation to symptoms. Okay, let's just come to.
But Linda, you must just understand. I think that's all fine and well when you're in a big company with highly trained staff and so on. But we're a mom and pop store. You can't expect them to be diagnosing staff. Oh, I think this person might have hepatitis.
Yes. No, absolutely. And I think that's why, you know, obviously there is the need for a medical practitioner. And Deborah has a question in relation to this, and perhaps Jabu, you would also like to comment. The law says that we have to use the services of a medical practitioner. Now, does that mean an occupational medical practitioner? Because, I mean, that's obviously a specific speciality. That's not just a GP. Could it be a clinic sister? Could it be a GP? You know, is there a particular interpretation of what level of medical qualification is needed in order to perform the requirements of either the hygiene regulation or, in fact, the hazardous biological agents?
Okay, we are saying an occupational health practitioner, which can be an occupational health nurse who has undergone I think there's a diploma that they do in occupational health. It's only
Yes.
those cases that might be maybe tricky or that needs an occupational doctor to ascertain them. But an occupational health nurse, it's okay.
Okay. Now, Janusz, in the context of the hygiene regulations, it states medical practitioner.
Yeah, so there was very recently, in fact, just to bear out what Job was saying, a Labour appeals court case, which the whole question about who can issue a sick note, which I suppose in reverse means who can issue the note that you can go back. And in fact, the court ruled that it can't just be a normal nursing sister, it's got to be one with this further diploma who's able to diagnose illnesses. So the medical practitioner probably doesn't have to be a medical doctor, but must be someone who has at least been trained in diagnosing illnesses.
Yes.
Because otherwise, how would they be able to say, well, you're fine to go back on it?
No, absolutely, absolutely. So I think the important thing here is that it must be someone with adequate competence, because that's what we're relying on. We're relying on that person to give us this information, and so it's really important that we take that into account. Janusz,
Yes.
if we talk about the pre-employment medical, so Jabu gave us, the interpretation of what's required by the Occupational Health and Safety Act and the regulations. There is no mention in the hygiene regulation of a pre-employment medical to determine whether or not someone would be a carrier of a disease that could be transmitted via food. What is the standpoint with regards to this from the Department of Health?
So look, you must remember that, so it's a bit tricky because that regulation 11.2b1, or let's say 11.2 as a whole, is reactive. It says that a person may not handle food if on his or her body they have a suppurating abscess or sore or a cut or this or that, or if they have symptoms, etc. So this is not a person who walks in, looks healthy, and you have a medical to see if they're fit to work. So this regulation doesn't require that. We need to be careful that a condition something isn't allowed to happen in your food facility which could contaminate food or spread illness. So an employer should probably, as part of the medical, pre-medical that is being done at the Department of Labour, add what needs to be done to ensure that food handling.
Regulation does not require it, but the Meat Safety Act in this case does.
But the Meat Safety Act is under the Department of Agriculture.
Right. Okay. So another interpretation, but I think important for those of you that may be working under the Meat Safety Act and the regulations. In fact, Janusz, as far as I'm aware, the Department of Health actually has a guideline, a policy guideline, which says they do not recommend the use of pre-employment medicals as an effective means of medical surveillance. As you've said.
No, they've always, look, they might change now with the way the world has gone, but they've always been very wary of using medical testing, etc., to exclude people.
Yeah, absolutely. Because as we know with, even with the coronavirus, I go for a test today, but that test is only valid for 72 hours. And I have to then self-isolate after that test because we cannot be sure whether or not, you're going to be infected tomorrow, and therefore, sort of void the status of the test. So I think that's that's really important, and the same applies when it comes to foodborne illnesses. Emma has got just mentioned a good point with regards to Legionnaire's disease. I mean, I know Legionella is not transmitted via food, but I think it's definitely a hazard that we have to be aware of in food companies, because we often are working with chilling systems, chilling water, air conditioning systems, and of course Legionella is definitely, it's one of the ideal opportunities for growth in that respect. Okay, there's a couple of questions with regards to the COVID regulations, so I'm just going to consolidate those and then we're going to wrap it up, because I think we've looked at this from a number of different perspectives. Janusz, just a comment regarding the POPI Act. So I know this information now becomes it's personal information, the records relating to, even pre-employment medicals, medical surveillance. This is now personal information. how do we deal with this when it comes to the protection of this information?
So in terms of the Health Act, if I remember correctly, all medical records are in any case confidential and cannot be distributed without the permission of the patient, etc., etc. So yes, there's another law, but effectively that's been the law, that when you've got people's medical records, they have to be kept confidential, etc. Your risk with POPI is that if you have computers which aren't secured and so on, and people's information gets out, not only will you have problems in terms of the Health Act that people's medical information got out, but you could be prosecuted under POPI for failure to secure personal information. But in terms of POPI, it's a category of personal information that needs to be kept secure, but that's to some degree a duplication of what is already in the law in terms of patient rights and so on.
Jabu, what about from your perspective? I mean, in relation to this, how would you handle this on an inspection? I mean, when it comes to this kind of information, would inspectors have the legal right to access these records? In the food industry, we have loads of audits, but we know, and we never give access to the actual medical records to the auditors. How does it happen from an inspection perspective?
No, also with the Department of Labor, we don't have access to the personal medical records of employees, and unless that employee give consent for those records, but we are not allowed to have access to such records.
Okay, right. So I think this is, across the board, we have to protect it. And, I think in relation to this information, even the Employment Equity Act, from my understanding, also has some requirements in terms of medical testing. So we do need to consult a number of different pieces of legislation with respect to how this is done. If I'm not mistaken, the employee must also give consent for even for medical testing.
Sure. I mean, medical testing is a personal, private, invasive type of situation. So yes, you can't force someone. Look, maybe under the Disaster Management Act, they can compel people to be tested. That still might end up in the Constitutional Court. To what extent can police jump out of a van, grab you, and take you for medical testing? But in general principles, you can't. Any medical testing would require the permission of the employee. Having said that, if the employee refused and yet they appeared to have symptoms, then they could be, first of all, suspended and I suppose eventually dismissed.
Yes, absolutely. And I think there's obviously implications to the employer as well in that regard. Okay, last question, and then we can wrap this up. With regards to the disaster regulations with regards to positive cases, so Jabul, maybe you can also assist. Currently, as you said, it is important for us to, if there is a positive case, it has to be reported to the NICD, and obviously there's the involvement from the NICD in terms of that case. There is, and that requirement falls under the disaster regulations. What about this reporting of screening? Because that's now a new requirement that came into effect, as Janusz said, on the 1st of October. Are we required to do this for anyone on our site, as including outsourced maintenance contractors, anyone that we screen? Do we have to submit this information every week? Is that correct?
Okay. When you conduct, you just say screening when people come into your workplace.
Yes, that's right.
Okay. My understanding, I might be wrong, is that when you screen people and then you've got the positive cases identified, is those, you need to keep records of your screening of all the persons coming to the workplace, but the ones that you send to NIOH is those of positive cases. But I stand to be corrected.
No, I agree. That's a view we've taken at our offices, so I hope it's right.
Thanks everyone for being with us today. We do appreciate your time. Thank you to the speakers. To both of you, we really do appreciate it, and keep the questions coming. We will post the presentation on our website. Thank you so much to both of you for being with us today.
You're welcome.
Thank you very much.
You.